Today's our Leaders Edge Tuesday, 11 o'clock Zoom. And today we are bringing you guys. So our goal every week is to bring as much value as we can to the agents that are in our network. Whether you're with the brokerage that we're with or not, we welcome everybody to join these Zooms, get on, try to get something out of it. You know, our goal is that you leave with at least, a few takeaways that you could implement into your business, or you could, put and integrate into your business plans. Today, we are joined by two special guests. We have Larry Bell, Esquire, who is an attorney, but also VP of CATIC Title Insurance. And with Larry is our good friend and strategic partner, Chris Brown. Chris Brown, for anybody that does not know Chris Brown was the owner of Remax Connection. They're located in Southern Jersey. They had a dynamite agency, multiple office locations. Chris and his wife, Deanna Brown, who many of you guys probably know. Deanna leads a lot of the EXP tutorial Zooms. And if you guys could just mute, that'd be great. If you're not muted, please mute. But for any of you guys that don't know Deanna Brown, Deanna has also been very instrumental in educating a lot of our agents that are in our network over the past year and a half. But Deanna and Chris ran Remax Connection, and in 2021, they brought their entire agency over to EXP, as many of us did, and now they are the Connection team, Mega Icon team, brokered by EXP. Chris is also the managing partner of Unitas Title, and also the owner and CEO of ClosePoint USA. And he'll talk to you guys a little bit more about that and the benefits that they're bringing to the table. If you guys could mute, I'm ready to mute everybody. You guys got to woke up today with the worst throat. All right, I just got the culprit that was making all that noise. Jeez. I found him. So anyway, Chris is also the CEO of ClosePoint USA. Chris and all of the, team leaders and strategic partners that are in our network, we're always looking for new ways and, ways to improve the closing process across the board, whether it's with title, whether it's with mortgage, whether it's with the attorneys that we're working with, whether it's with, equipping the agents with just better skills and tools and knowledge. Our goal is to make your jobs easier for what you do every day, closing deals. That's the goal. We want you guys to focus on selling homes. That's why we brought TCs into the equation. We brought a whole team of transaction coordinators in this past year. A lot of the agents are utilizing it. If you're not, you should. Again, our goal is to make your lives easier and arm you with as much, weaponry in your arsenal of tools as possible. So without further ado, I'm going to let Chris and Larry take it away. So welcome, guys.
Thanks a lot, Chris. Really appreciate you having us.
Can't really hear you that well, buddy.
Oh, okay. Sorry about that. Closer to this. How about now? Is that better?
That's better.
All right, cool. So I appreciate you having us. Today's idea, and I was talking to Larry earlier about this. Let me explain who Larry Bell is first. Larry Bell is the title guru of the industry. I've been working with Larry for more than 20 years. Larry is, well connected within the title industry, well respected. You think you're dealing with an expert, when you're on the front lines, but then there's another level of expertise in the industry, and that is Larry Bell. He is the standard bearer of understanding complex issues and being able to apply common sense as well as the law to create those resolutions and resolve those issues and challenges that we face. So I thought it was a good idea, and Chris and I talked that we bring Larry on board as our reference guide for each of you to get an idea of the mindset that goes into resolving challenges, and also not just resolving, but also being prepared to resolve a challenge before it becomes an issue that delays your closing, which is huge, especially in this market, because there's such low inventory. And because of that, we want you guys to have and be prepared what could be a challenge and resolve those well before it gets to the near end of the closing deal, and that could blow up the deal. So one of the questions that I get is, when should an agent think about closing a transaction? Believe it or not, the day that you sign that listing agreement with your client to sell their property is the day you think about closing. You have to prepare on that first day. And what do I mean by that? And I'm going to bring up a couple issues and I'll have Larry jump in. Number one, is the person signing the contract authorized to sign the contract? If you're dealing with an LLC, you're dealing with an estate, you're dealing with a trust, do you have the appropriate person signing the listing agreement? You don't know how many times that we do get along the transaction and we find out that, quite frankly, the person who signed the listing agreement doesn't have the authority to sign the listing agreement or sign the contract. And pretty much the contract is non-enforceable because they didn't have the right to sign that and execute that agreement.
Hey, Chris, I'm not interrupting, but if you could turn up just a little bit more somehow.
Turn up a little bit more?
Yeah.
How's that?
Yeah, just as loud as you can get.
Okay, cool. So I'm going to bring on Larry Bell to talk about the differences of who has the authority when you are dealing with an estate, a trust, or an LLC. What should be going through your mind in that moment to deal with those three issues? Because if you don't have the proper person signing those documents, your deal can be terminated. And Larry, if you could pick up on the differences between the two LLCs, what you look for as a title underwriter of who has the authority to sign those contracts.
Thanks, Chris. And both Chris's appreciate the kind words and certainly what you're doing here. These weekly programs, it's my hope and expectation that we get more familiar with each other, that you call upon me to assist in specific topics on a going forward basis, because it's so important for everyone to be on the same page. Chris says you start thinking about closing on the day you sign the listing agreement. I would add, to some extent, and then every day thereafter until you get to the closing, because you are the folks that are on the ground dealing with the parties. You have the most contact with the parties, so you're in the best position to be the fact finders, to determine when you're dealing with someone who doesn't have the authority to sell the property. They may hope they did, they may wish they did, they may think they did, but if they don't, the seller needs to be able to sell, or they're not sellers. And who on behalf of the seller has the authority to bind the entity is very important, and is kind of the basis of Chris's question about who can sign for estates, trusts, and LLCs. One thing before we get into it, I have been doing this since the late 70s. I had a very active real estate practice in North Jersey, probably did 5,000 plus closings on my own before I joined title companies. Been working for title companies since '94. Thank you for the vice presidency reference, but I'm a senior vice president, not that that makes any difference, and a senior underwriter in the state of New Jersey. And as more and more senior people are retiring, I think that makes me more senior. So that's kind of why Chris says I'm the guru. The answer to any of these questions from my perspective is getting to the yes. That's our area of expertise. Other people can get to the no pretty quickly. I never get to the no. We always have the answer that will get us to the yes. What's going to get us to the closing? What's going to resolve the issue? How can we anticipate What we need to do to get to the yes, so that everybody's smiling at the closing table, even when the electricity wasn't turned on for the walkthrough, and we're talking about maybe escrowing a couple of dollars. But from the perspective of having the right parties, certainly when you're dealing with individuals, it's easy. Mom and dad are selling the house. A single individual is selling the house. They're the people that need to sign. If one of them becomes deceased or they're both deceased, the record owners are both have passed on. So we're dealing with an estate. Now we need to know who has qualified to bind the estate. Usually with a will, there's an application to surrogates court. Surrogates got really crazy during COVID because their offices were all closed. We couldn't get good information. We had to find workarounds to how we bind an estate. Sometimes we may have to use heirs and beneficiaries and get affidavits to get to the right place if we don't have a good qualified administrator or executor in through surrogates court. Same thing for trusts. Is there a trustee appointed? The trustee is the party that can bind the trust, not the beneficiaries. That could get crazy if parents put property in an irrevocable trust and appoint one of the children the trustee, and then they say, hey, we're going to sell, but they may have given up that right. So we need the kids to participate or cooperate. And LLCs or any business entity, we always need to know who the owners of that entity have appointed. A sole member LLC, it's pretty simple and straightforward. We get a resolution. I'm the sole member. I'm the guy that can sign, or the woman that can sign. If there are 3 or 4 owners, they have a meeting and they appoint an authorized signatory. So-and-so has the power to bind the LLC. One thing about all 3 of those issues, estates, trusts, and LLCs, each and every one of them serves in a fiduciary capacity, different from an individual capacity. You can't give a fiduciary capacity by a power of attorney. So if the estate executor, the trustee under the trust, or the authorized signatory of the LLC realize that it's their golf day when you want to close, and they're going to give a POA to somebody to sign on their behalf, that's going to hold up your closing, because you can't give a POA of a fiduciary capacity, only an individual capacity. So these are some of the issues that we deal with. Occasionally, with commercial deals, you may have various different conflicting factions in a corporation or in an LLC where someone wants to sell and somebody else says, no, we're not going to sell. We should keep it for another year. Certainly, if we're seeing any LPs, or Liz Pendens, an indication that there's a dispute over title, over the sale. Certainly, we need to stop everything. Anytime there's any litigation, good question, is there litigation pending or threatened over title? That holds us up as well. And that needs to be addressed probably before the contract is even signed.
So let me jump in real quick. So from the agent's perspective, it's very helpful to your transaction to gather this information when you take the listing. Again, your mindset is when you take that listing, you're preparing for closing. So when you're asking, you're the person signing the listing agreement, and let's say it's an estate, you should ask them for letters of administration from the surrogates court that they have been appointed to probate or to administer the estate and have the authority to sign the documents that are necessary to transfer ownership of the property to a new buyer. You should ask them for a copy of a death certificate that may not be of record. If they just passed away, the death certificate may not been, or the will has not been probated yet. So if they do not have a certificate of administration from the surrogates court, your next step is, okay, can I get a copy of the will? Can I get a copy of the certificate of death? So this way, you can forward that to the attorneys and to us, and then we can see who has that authority and track. Also, things that we look for, and we don't have to get in the weeds of this, but is inheritance taxes. Are the beneficiaries within the will Class A or Class C beneficiaries? If they're Class A, they're exempt from inheritance tax in the state of New Jersey.
Yeah.
However, if they're
Brothers, sisters, nieces, nephews, cousins, anyone that's not a direct descendant, I mean, if there's a sale and they're the beneficiaries, we need a tax waiver of record. We can always escrow for that, but it's something that, it's so much easier if they're processing all of those steps at the same time as the sale.
correct. And so those are the documents. And from an LLC perspective, ask them for the operating agreement. If they do not have an operating agreement, they need to speak to their attorney that is going to be representing them to prepare documents that authorize them as the authorized signer of the LLC. A resolution. You should have a resolution in your file when you take that listing agreement. Because now, if they don't have that resolution or have the operating agreement, and you have not verified that they have the authority to sign on behalf of the LLCs when there's multi-members, it could present a problem for your listing later down the road. So that's another question you should ask is, do you have your operating agreement for your LLC that I'm about to list your property? So I can identify you as the authorized signer on behalf of this contract that we're entering into. I'm not talking about the real estate contract. I'm talking about the listing agreement at this point.
Chris, let me just make one other point. While we're talking about who the parties are, and making sure that we've got the right parties, we also want to make sure we're not dealing with the wrong parties, people that are charlatans, people that don't have the right or the power, people that are not who they say they are. And, one of the there are a number of red flags, but one of the red flags would be if you're taking a listing on a property where you believe that the value of the listing is less than the fair market value of the property. Someone's looking to make a quick sale, and that there are issues. I mean, the properties similar on either side of the block are going for 380, and somebody's listing this property for 199 or for 220. Those questions are questions that are going to be asked. Is this a preferential transfer? Is this being parked with someone, to avoid judgments or to prevent or to perpetrate a fraud of some kind? So that's something else to keep in mind. If you see something, you're asking questions about LLCs and who has the power to sign. If the answers that you're getting, and when the hairs kind of stand up on the back of your neck, that somebody's given you a line or that you're just not feeling right about the people you're dealing with, it's best before we get too far into the transaction to ask these questions. The more people push back, the more we would kind of want to make sure that we've got a legitimate transaction that we're about to devote our efforts and energies to.
So therefore, as a listing agent, when dealing with an estate, your first question is to ask if they have letters of administration that gives them the authority to administer the estate and that the will has been probated. In lieu of that document, you need a copy of the will to verify that person is the appointed executor prior to it going to probate, that they can sign the listing agreement with you. You will also ask for a death certificate in that scenario, because a death certificate is not of record at that moment. So therefore, those are documents that you should definitely ask for. From an LLC perspective, ask for the operating agreement, and make sure that it's signed as well. And from a trust standpoint, asking for the trust agreement. So you can take a look and see who has the powers of the trust to sign that listing agreement. Again, you don't want to take a listing that the individual that is signing your listing agreement doesn't have the authority to do so on these three entities.
Chris, there was a question about letters testamentary versus letters of administration. If there's a will, letters testamentary are what you're applying for and what will be issued. They'll appoint the party named as the executor in the will. If there is no will, it's letters of administration, where an interested party would file the application. So it's either the executor or the administrator, and we use those interchangeably. They're both appointed. They're both going to get official documents from the surrogate's court, either letters testamentary for the executor or letters of administration for an administrator.
So the next thing, because we've gone through those three types of entities, but I also thought that we should mention what are the documents that you should ask your seller for, so you can, again, with the mindset of preparing for closing, at the moment you take the listing, is their owner's policy. The seller has an owner's title policy. That is extremely helpful in the process of searching property. It limits how much we have to search. It also clears up any back title issues. There's a policy, and Larry, if you can explain what the title treaty is amongst underwriters when dealing with prior liens and mortgages, once there's an owner's policy without exception has been provided to the seller. If you can explain that real quick.
Sure. For starters, when we rely on an existing owner's policy, what we're relying upon is the search work that was done by the agency that issued that policy. And we know there's search work because we're seeing in the policy conditions, restrictions, easements, matters of record that go back to the 50s, to the 60s, for a period of time. So we're relying upon the search work that was done in the past to get to the point where we know we've got a reasonable period of time. There are areas, thankfully New Jersey doesn't have many, but there are areas where mineral rights may have been divested because there was Marcellus shale. We see more of this in Pennsylvania than in New Jersey. If you don't go back far enough, you may not pick up a mineral severance where somebody has a right to come in and dig. That's not something you want to have happen, especially when you're selling the property where they want to dig up the yard. But the indem treaty that Chris referred to, all of the underwriters in the state of New Jersey have signed on to an agreement that says, if you have my policy and you're finding something that's wrong, something that doesn't exist in my policy, I issued a policy free and clear. It doesn't have any predecessor mortgages that are still open of record. And then you run your search and you see 2 owners ago, someone signed a 30-year mortgage 20 years ago that's still open of record. Well, the indem treaty says that you can rely on the treaty to pass on that mortgage. And if that mortgage becomes an issue, it's the predecessor title company's issue. It's not my issue. So Chris could insure free and clear if he's got the owner's policy. So we're relying upon both the liability that was undertaken by the previous underwriter, and we're also relying upon the search work that's been done over the history of time. I mean, in 1965, when you did a search, it only went through 1965. The joke is U.S. history, when I was in the 8th grade, didn't cover very much. And there's a lot more that's happened. Certainly a lot happens after policies. So if we search from the date of the policy until the present, which we're allowed to do under underwriting guidelines, we're fine in terms of finding and taking exception for everything that's out there. But the existing policy of title insurance is something that's very helpful.
Absolutely. So what your takeaway here is, it reduces the amount of search time that we have to take as a title agency, which then we are able to issue a commitment much faster. And it also clears up any prior title challenges that may be of record that we can pass on, that we don't have to hold escrows for. So that is why the owner's title policy for your seller is extremely important. It is more important than their original deed that they've had already recorded. So yes, the owner's title policy is absolutely important, and you should ask for it. Another document that will help out and expedite, and we can get into affidavits of no change, is a survey. If the prior owner has a surveys today now cost between $750 and $1,000. So let's say you're doing a single family house that the buyer or the seller just bought 5 years ago and they're ready to move. And they didn't do any alterations to that property. They're willing to sign what is called an affidavit of no change, and they submit that prior survey to us. We'll take that survey and endorse it into the binder, and we'll not have to order a new survey. And then that prior survey is now insured under our title policy based on, and we rely on, the affidavit of no change that the seller would sign. It saves your client $750 to $1,000. It saves time and it saves a lot of effort. So that's a big win for the buyer if you present that document from the seller to the buyer. It's also a real good feel piece, because you are saving the buyer a lot of money, and you're helping them out, and you're helping the transaction to move forward. So that's a nice olive branch to provide to your buyers. Any questions on that, Larry, or anything you want to add to that, Larry?
There are circumstances where the existing survey is going to present issues that make it more important that a new survey be obtained. It doesn't happen that often, but I would caution that we temper the request for the survey. If in a perfect world, in a grid system, 75 by 150 foot lots, 50
Right.
by 100 foot lots, where we've got a filed map description in the background. Absolutely, I agree completely. If it's a rural piece with 30 different courses, it may be that old survey, that a new survey is something that's important. We've seen issues where, had a survey been done, we would have discovered the bridle path that crosses the rural piece of the property that neighbors have been using, for horses or for some other purpose for 50 years. These are things that we would need to know about and take exception for. For the most part, yes, the expense of the survey could be avoided. The same way the expense of setting corner markers is something that could generally be avoided if you do need a survey. Tell the surveyor, if you're finding the corner markers and they're really close, don't go charging me an extra $250 a corner, to move them a quarter of an inch or a half of an inch. So by having these conversations, you can save money, but there are times that things will be disclosed where it's really in the best interests of the buyer to make sure that they're well protected, because every buyer is going to one day become a seller. And if they're a happy buyer and they're going to become a seller, you want them to be happy with you.
Absolutely. Another component to documentation is when you're dealing with a property that's either a condo or a PUD, a planned unit development. Those properties are subject to, well, a condo is a master deed, which creates a homeowners association. A planned unit development is guided by covenants, easements, and restrictions that set up another homeowners association. So you should ask your client, your seller, for their contact information, believe it or not, for the management company, because we need a statement of account as well as documentation from the management company that oversees that association. You would be shocked to find out how many times we get to closing 3 days before, and the seller's attorney or the buyer's attorney, nobody has the contact information for the management company. And it delays the process, not only from title, but also for the mortgage company, because they need the statement of account. By the way, to order a statement of account, it is a buyer cost. It costs about $400 to get a statement of account now. So, and they're also taking up to 72 hours on a rush to turn that around. So my point to all of you is, please get the management company's contact information when you're dealing with a condo or a PUD. It will absolutely help streamline your transaction and make that closing date a reality. The last component that Larry and I spoke about that we wanted to impart with you guys is a lot of you are in Monmouth and Ocean County. You deal with tidelands claims. Big deal, tidelands claims. You deal with bulkheads. You deal with docks that were once established 15 years ago, and the dock is now being replaced, and the dock was augmented, which is outside the footprint of what is allowed for that property. So now, I wanted to get in where you guys can actually request from ClosePoint, Unitas, a flood cert and the tidelands claim search. When you take that listing to ask for those items, can absolutely help you streamline the process and avoid a delay in closing and a challenge to your closing by identifying any state of New Jersey tideland claims against the subject property that you're selling. Larry, would you want to add on to that?
I do want to add on, but first I'm going to comment real briefly on the condo issue. We do have a law in New Jersey that says that the condo association has to reply within 10 days to a request for information, and the reply that they give you is binding. So if they messed up, if 3 months later it turns out that there's a lien, that there was a foreclosure or a predecessor where money is owed, and they don't disclose that in the report, the law says they're forever bound, that it's binding on them, and that's something that can be requested by any interested party. One other thing, because Chris was talking about PUDs and condos, I just want to say a word or two about co-ops. If you ever encounter a co-op as a listing, everything you know about real estate is wrong when you're applying to that co-op. So we have a lot of expertise when it comes to co-op sales. They're very, very different. And when people assume that they're not different, or when lenders go and put a first mortgage on a co-op like it's a condo, those are issues that we need to deal with. So whenever you're talking about a condo, things are very, very different. Getting into the riparian, the riparian maps were filed in 1988. After 1988, we know exactly where riparian claim areas are. And what we're talking about is any area of the state of New Jersey that is now or was formerly flowed by the tide. So it's the entire Atlantic coast, down around the southern tip, and then all the way up the Delaware. Anything that's affected by the tide that is no longer affected by the tide is still a riparian area, and it's owned by the state of New Jersey. And if you don't have a grant for that area, you don't own it. And at the time of sale, the buyer has the right to make you, seller, either get a statement of no interest or apply for a grant for that property. And if the property has a grant, but the current owner has owned it before 1988, and the grant was obtained before 1988, chances are that the grant doesn't cover the entire tidelands claim that exists in 1988. So it may be that a seller who thinks that they own 100% of their property may actually own, maybe the claim area is 800 square feet and they have a grant for 600 square feet. So what they need is small, but it's still something that they need, and there's still a substantial expense. So if you are in an area that is affected by tidelands, and we have a little map of the state of New Jersey with boxes that show every single area that's affected by tidelands. We could, Chris can distribute those, or we can give them to Chris Walsh so that everybody has this little map of New Jersey. If your property is located nowhere near where these little boxes are around the perimeter, you have nothing to worry about. But if you are located near the shore, even if you're up in Bergen County, which has, Hackensack River is tidelands, any waterway that is or was tidelands, Hoboken full of tidelands, these are all areas where you need to anticipate what the requirements will be. It is what it is, but it's a lot easier dealing with a seller who knows week one that they're going to have tidelands issues than showing up at closing and telling a seller that they're going to have to escrow $250,000 of their $750,000 sale proceeds. So very important to understand what's out there and what you're dealing with. Same thing with a license for an existing dock. Unfortunately, we had a situation where the grant was before 88. They had a grant that didn't cover. The buyer got a survey that added the additional square footage that needed to be covered by a Tidelands grant. And while they were working on the grant, they noticed that the dock for which there was a license was twice the size of the approved dock. So that the seller had replaced the dock at some point in the past, never got permission to do that. So now not only do they have a Tidelands issue, but they have a dock issue. We're being told the chances of their getting consent from the state to increase the size are not 100%. You know, they're saying the easiest thing would be to take a chainsaw and cut off a piece of the dock. Not exactly the discussion you want to have with your seller or your buyer. So anticipating these is great, and Chris can get you those searches if you are in an area of concern.
So
I have a question. What's a tideland? Is that a flood zone? I'm lost.
So tidelands are defined in the law of New Jersey as an area that used to be flowed by the tide. So at high tide, any area that is covered by water or was covered by water is tidelands. I mean, you could go to an area that used to have tidal tributaries that have been closed off, where the tide no longer floods those areas. But if they were formerly flowed, the tideland flowed on those areas in the past, those areas are owned by the state of New Jersey. And we have to get a grant from the state of New Jersey, like a deed. So if you are successful in getting a grant, maybe it'll cost, you know, it's the value of the land, you know, and there are ways that they determine what that cost may be. And when that cost is paid, what you get from the state is called a grant, but it's a deed from the state of New Jersey to the uplands owner, to the owner of the land that adjoins this tideland area, that says you now own 100% of it. And once that's in place, it's never an issue in the future. But we're still seeing properties owned since the 70s and the 80s and the 60s by, you know, grandma and grandpa who are now long gone, and parents are now, you know, have been living there and it's changing hands. They may very well have tidelands issues. The good news is when grandma and grandpa bought it, they paid $37,000 for it, and now it's worth $1.8 million. So, you know, if there is some tidelands expenses that are involved, you know, hopefully it's not something that that is going to hurt anyone that much.
Senator, what happens is in a tideland search, it will give you the box of the property, and it will show you what portion of the property used to, at one time, had tidal flowed waters above that property. Those waters may have receded, and the property may have built up.
Accretion.
Yeah, exactly. Built up to, you know, where there's now land there. Now, because those waters used to flow above that land, that's tidelands. The state of New Jersey has an interest in those lands below the water. You have to get the state of New Jersey to release their interest through a riparian grant to the uplands owner that's connected to that once flowed area. Very important. But a tideland search will help you determine if any portion of that land is still claimed by the state of New Jersey. Now, let's say it's not, there's no riparian grant, and there's a 5% interest by the state on the property that you're selling, and the property's worth $2 million. Not inconceivable, because you're on the water. So now it's that grant to buy it is, you get an appraisal, it's $2 million, 5% of $2 million. That's what the state's going to want for that piece. It's serious. And this is something the seller had no idea that, you know, this impacted their property. So here you are saying, hey, let's do a tidelands search. Let's make sure that there's no interest. Oh, I have a grant. Let's just do it anyway. it's 25 bucks. Let's do a flood search to see what flood community you're in. It's 10 bucks. That's a simple email to us at orders@ClosePoint USA. Our staff will put the order in and get the searches over to you. And it also makes you look very professional that you're taking these steps to get a $2 million listing to clarify any challenges that there may be on that big listing that you want. And it will set you apart as a realtor professional versus somebody else who's just saying, hey, I can get you $2 million for your house. But you're saying, yeah, I'm going to get you $2 million, but I want to make sure you close without issue. And I want to take care of your challenges that take place. That's what sets you apart in this industry. The last item that I wanted to cover that will really help your transaction out is COs. Make sure your property is compliant, with the CO requirements of your town. It's very important. Lenders do require, the law requires a CO. I know a lot of you are very good about this, but there are some that don't, I don't need a CO. They're not going to live in the property. Well, that's fine. If they're not going to live in the property, just get it a temporary CO from the township or some type of document from the township that they understand that this property is going to sale. Smoke certifications. Do you know that if you fail to get a smoke certification in the state of New Jersey, it is a $1,500 fine to the buyer, a $1,500 fine to the seller, a $1,500 fine to both realtors and to the title company that closed the deal. They can charge up to 15, in some municipalities, and I just read recently, can be up to 5,000. So be careful on that front with your COs and smoke detectors. Larry, did you want to add anything else to how to prepare your seller and buyers, for that matter, to purchase property so you can avoid challenges?
When you're talking about avoiding challenges, you need to know what those challenges are. Is there a boundary line dispute? Has one of your neighbors been contesting a boundary line, or do you think that they're encroaching? Or is there some other sort of dispute that needs to be addressed? Anything that that's going to have an impact on this closing needs to be shared. And the sooner that we address it, the easier we can come up with what the requirements are going to be and what we need to do to get to the yes. There's nothing worse than having moving trucks loaded and kids getting ready to go to new schools and maybe 3 or 4 closings relying upon, seller's money to be the buyer's money, to be the seller's money, to be the buyer's money. We don't want to get into nightmares where one of those pieces falls out because we didn't anticipate something that we could have asked the questions and dealt with, early on. But I think you've really, hit everything, some of the real major areas. One thing that Deanna just brought up, having to do with divorce, yes, very definitely, this is an area where always property is being sold, or generally if there's property owned by a husband and wife, and that property is being sold or refinanced, there are always issues that come up. There are always court orders that we may be relying upon, or you're dealing with more than one attorney who's trying to tell you the way something's going to happen without speaking to both attorneys for a husband and wife to have an understanding of where we're going. We always need to make sure that issues are properly extinguished. There's a whole slew of law. We could probably do a whole hour on just divorce issues. What happens if the husband doesn't take his name off quick enough and then a judgment goes on and the wife is now refinancing? How do we deal with that? So this is an area where if there is marital disharmony and the sale is something, it might be a sale and a refinance by the party that stays in title. So these are issues that can always present problems. Another question that just popped up has to do with tax liens. And of course, If there's a tax sale certificate, if someone ignored an item that can become a municipal lien item, a sewer charge, a water charge, taxes, it's a property that was vacant, the grass wasn't cut, the municipality came in and did property maintenance, there's a property maintenance lien, there's a vacant property lien. These are all issues that can hold you up if you don't know about them early on.
So, we can go into what we provided you today were the topics that are challenges that delay closings that I've seen in the 44,000 closings that we've done, and Larry probably over a couple 100,000 that he's seen. These are the primary issues that we pick up on, that we noticed that could have been easily avoided had the agent had the mindset from the day they took the listing. That is the day they start thinking about closing. Quite honestly, you have to think about it from day one. I want to use the last 10 minutes of the time to make sure we cover the questions that have been asked. And some go back to previous subjects. So here's a question. If a fence was added onto the property, does that mean a new survey needs to be done? I was in the car and I couldn't ask earlier. So the answer to that is yes. And Larry, you can disagree with me if you want. You would, because you want to make sure, first of all, is it a chain link fence, a standard fence, or is it a monument fence that cost $100,000 to put into the property? You want to make sure that fence that was installed is not encroaching on the neighbor's property next door. We had a situation where a client who signed out and didn't want a survey done, the seller didn't have a survey, they bought the property, they had an installed fence for $125,000 that encroached on the municipality's property in the back. The municipality sent a notice to the new homeowner that their fence is encroaching on their property, and it would cost $45,000 to move that fence back onto the subject property that they bought. So yeah, I mean, you should, if there's any alteration between the original survey that the seller has and today's property that's being sold, 100%, you should get a new survey done. But if that seller is willing to sign the state that they didn't have any alterations, the fence has already been there, the deck was there when they bought the property, and that survey is accurate and true to what the property is today being sold, you're going to be pretty okay. I mean, you're going to be fine, unless the seller decides to lie, and then that fence was put in after they bought the property.
Thank you.
No problem. Here's another question. Let's see here.
Steve
Do
Slack.
HOAs have to provide info prior to getting under contracts? I contacted an association to give my client info on a condo she was interested in, but the association said they don't provide closing fees until after contract. Larry touched on this. Larry, if you want to go back to that statute that any interested party has the right to request this information, I believe yes, you can get that information, but I will tell you right now, the way you're going to have to get it is going through the website portal for the association, and believe it or not, your buyer will pay a $400 fee in that area to get that information you're looking for, because it's a statement of account that you're requesting. However, if the seller is forthcoming and you're dealing with the seller can provide their statement that they get every month from the association that details what their monthly ongoing fee is. It won't detail the incoming fees, like the working capital. It won't detail the new membership fee. It won't detail the escrow for, that's held for monthly fees. So, there's other fees that will be applicable to your buyer that statement won't disclose. So you're going to have to rely on, if you don't go through the association and pay the $400, you're going to have to rely on the seller's representation on that.
Yeah, the statute that requires the association to reply when we're talking about interested parties, they would be talking really about a buyer that's in contract. But for the purpose of marketing condominiums, you need to know what the monthly maintenance is. And that's information that should be very readily available. It should be readily available from other sources online. I think the specifics of a particular transaction, I mean, no one is going to have an exorbitant amount of initial capital contribution, maybe a month or two. And, you know, brokers that handle particular buildings and particular condos, you know, if it's not your first rodeo, you pretty much know what the requirements are for each of these buildings that you're dealing with. But yes, very definitely, you know, the general information should be readily available. And as far as getting the specifics, what you want to make sure that you've done is not put your buyer into a position where there are arrearages or there's money owed by the seller that hasn't been addressed, you know, or that there may be some requirements, you know, an approval requirement or a flip tax requirement or a right of a first purchase right, which you don't see very often, but it may be that a condo association has that within their body of their master deed.
You're representing a buyer.
Can't hear you.
Buying a condo. Just go in with the frame of mind that your buyer will come in. They will pay about $2,500 in closing costs to come into that new association. That's the number that we use when there's not a state account available. We hold $2,500 against the buyer, and we hold $2,500 against the seller to make sure that the seller is up to date on their dues and they're not in violation of any of the association rules and regulations and have fines against them. I'm going to go through and see what the next one is. Also, where is that? Okay, can I please get that map with tidelands?
Yeah. I tried to send it to you, to both Chris's. It went through, Chris, it's in your email, and Chris Walsh, I don't have your new email address.
Okay, it's chris@therealestateleader.com.
Okay, so I will share those. I also tried to post it to chat. I can't figure out how to do that, but
you just paste and drop it into the type message here area.
Yeah, I thought that would work. Let me see if I can open it on my machine and do that, because I do have that right here. And it's an interesting,
I just made you a co-host, Larry, in case that helps.
Oh, I got your email, Larry. I can do this. Hold on.
yeah, if you can post that, I can just kind of, you know, explain how folks can superimpose their location on that key map.
Yep, I'm just going to save this to my desktop. And
while you're doing that, I just wanted to intervene a little bit and just kind of say a couple things about everything that you guys are talking about today. You know, one of the biggest things in becoming an effective, you know, producing agent is just being proactive. And I mean, that's first habit of the 7 habits, right? Be proactive. You got to get in front of obstacles before these obstacles become problems. It's little things that we're not thinking about that become major issues down the road. And that vision that, you know, Larry or Chris was sort of putting out there with your client with the moving trucks, you know, and they're trying to, you know, line closings up on the same day, and everybody's crazy and everybody's stressed out. There's nothing more stressful than moving, right? And they have their kids and everyone's just ready to kill each other, right? And then all of a sudden, because listen, a lot of these attorneys don't order title until very last minute. You know, I don't know what it is, but they really don't order title until they know the deal is very, very solid, right? And there's nothing worse than like day of or day before finding out that there's an issue, that there's a tidelands issue, finding out that there's an old mortgage that's coming up on the property, you know. And I've been in that situation, whether I'm on the listing side or the buy side, and it's definitely not fun. Okay. And as far as getting like the HOA docs and all that stuff, again, very important when you're working with an HOA to make sure you get the statement of accounts and make sure you get the information from the management company. Because again, these management companies sometimes take a while to get back to you. They're not very responsive, and you know, you need to be proactive.
I just shared my screen.
It's also in the chat box too. I added the map to our chat box as well.
Excellent. So everybody should have this map. I don't know if you can see it on the screen now. Participants can now see your screen. So you see a map of the state of New Jersey with little red boxes around the outside. If your property is not located anywhere near those boxes, you have no riparian issues. You know, if you're up in Sussex or Hunterdon or, you know, those counties that have no red boxes, they're nowhere near the water, no problem. But if your property is located around the perimeter of the state, those are the areas that have riparian claims. So just, you know, something that's helpful, you know, find your property on a state of New Jersey map, make it the same size. If it's in a white area, you're fine. If it's in a red area, you may want to think about it.
Sure. And again, we if you have one of those properties, and if you're down the shore in Monmouth and Ocean County, just send me an email to orders@closepointusa.com and say, hey, I need a tidelands and flood search. And then we'll put that order in for you and get those searches over to you guys. You can get us reimbursed at the time of closing if they're not using us for closing, but we can certainly wait. It's like $35 for both reports, and we'd be happy to get it to you and wait until it closes. That just be added to the closing. So we want to make you guys better. We want to make you guys look like, you know, of course you're on top of your game from a marketing standpoint, but not only that, we want you on top of your game on the functionality of the transaction so you can resolve issues. The more you guys know about this stuff and prepare for, the more you're going to look like a hero to your client, the more that they're going to refer you out, that you're an expert in what you're doing and that you're aware of challenges that exist in that area and that you're prepared to deal with those challenges and get them resolved before they become problems for your closing. You know, and Larry started off this whole discussion by saying, we're not people that look to say no. We don't do the business that we do because we give out no's. We're the type of people that are looking for yeses and solutions, and we do these things very quickly. Our staff's responsiveness to all of you is hypersensitive. We want to make sure you guys get what you need as quickly as humanly possible. So that's why we're here for you. ClosePoint is the settlement division. They handle all of the numbers, the disbursement of checks, you know, coordinating with the mortgage company, coordinating with the attorneys and with the realtors. They're the hub of communication. Unitas and the other joint ventures, Connection Title, those are the policy issuing agencies. They actually issue the policy for CATIC. They're the entity that's ensuring the transaction. They will both work in harmony with each other. So ClosePoint is the settlement division for Unitas and all the other JVs that we have with our partners, which now there's about 13 of them. So we are absolutely your go-to. If you need us for anything, we're here for you. And we're your partner. We're your partner. We want you to close deals. We're going to find the solution to your problem. It may take longer sometimes. It may be within minutes. But rest assured, when you present us a challenge or a problem to your closing, that we're working towards a yes to get it closed. And we're responsive to you. So that's the benefit of using your partner, because we're here for you. We're in this together. We're not some title agency in a far off land that doesn't want to hear from their partner. We do. Email me, whatever you got to do to get me the information, I will get you the answers. And if I can't give you the answer, I go to Larry Bell, and 99.9999% of the time, Larry has the solution. And
anybody, if down the road anybody needs Chris Brown or Larry's information, and you guys have my information, feel free to hit me up for either of their contact info down the road. I actually just passed your information, Chris, on to one of the participants that was on today, one of the agents that was on today, someone from Sal Ventry's team. So he might be reaching out to you with a question. But listen, this was awesome. You know, I know when it comes to title issues and things like that, you know, it could sound a little boring. You know, it's not the most exciting topics in the world, but boring or not, all of these topics are vital in your transaction. And again, getting in front of it and staying in front of obstacles that are going to come up and become major problems down the road is key with you having a flawless, streamlined transaction. So